If you don't mind, also in the last row, I will stay here at the table without using the podium. The chair is with me, so I'm going to put forward. I actually start from the last presentation, not to step in your matter, but because it was a very good presentation, so thank you. And because the conclusion on the need to clarify what is identification and interpretation is key in approaching the topic in general. The Italian doctrine, there are several books that really went into the difference between ascertainment and interpretation. Of course, going back to the Latin idea of interpretatio, so as a rhetoric approach to written law, so interpretation is just for written issues. And ascertainment is when you look at raw practice and facts. This distinction comes from the contested validity of customary rules in the continental tradition. So the enlightenment and the purification of law in internal matters brought to the idea that centralized power could be clear, transparent, all the legality principles we know, and with the authority to write the law, while customs are actually the tricky beast to be avoided that led to French Revolution, that led to the possible conflicts between authorities in terms of judges. So this is a very strong tradition that informed our constitutional legal order. However, we also know from history of law that that kind of tradition also grounded the possible excessive of state authority and state sovereignty. And in Italy, it's one of those states in which the state decided to be very presumptuous against the individuals. So in 1948, when the contemporary constitution was passed, we see this total deference for written law with some openings to something different. Article 10.1 introduced a direct link into the Constitution incorporating generally recognized principles of international law. Of course, the idea was to avoid to have a leader taking the power like Mussolini and invoking laws written by the government against established norms for the European legal order. It's not just about the so-called Jewish laws in 1934, if I'm not wrong. But it was more about the Ethiopian crisis. So when Article 10 was introduced, the idea was to prevent Italy to move against the League of Nations, as it happened before. So this is the first limit that was put to curb the possible deviation of the state. The second concept was introduced in Article 2 and was the concept of person. In this case, it was not a legalistic approach, but was the French and in general Catholic reflection on the concept of person in the 20s. And third is a broad push for the inclusion of a generic clause in Article 2 introducing the rights of person. I will skip completely the second part, but it's just to say that in general, the Italian legal system is really skeptical about the existence of customs. And they've been introduced in 1948 as a way to avoid what happened before. In particular, an illegitimate use of force against the established legal system. Unfortunately for our research, or for Panos and the other research, beside Article 10, paragraph 1, dedicated to customary international law, other rules were introduced dedicated to written rules, treaties. Very dualistic approach, but also some opening for the EU legal system with some reforms. Why I say unfortunately? Because when good cases about the possible interpretation of customary international law are brought before the Italian Constitutional Court or the Supreme Court of Cassazione, often there is this distinction. Article 10.1 only regards customary international law that is unwritten. And therefore, when the court deals with it, it's all about the ascertainment of the rule, the identification. When there is a tiny bit of written law there, the court shifts into the written law paradigm and uses Article 10, Paragraph 2, or Article 11, or Article 117 going in the sources of the whole system. Therefore, it's very rare to see, for example, the reasoning so typical for the International Court of Justice, the 2001 draft articles on state responsibility, codifying the customary rules, or the Vienna Convention on the Law of Treaties, crystallizing the customary norms. Every time there is something written, the courts usually shift towards the interpretation of written test method. By the way, the Vienna Convention is kind of a taboo for our constitutional court. So when they approach treaties and other stuff, they use the proper way to interpret legal text. They don't use the standard international law approach that every written text, treaty, MOU, and whatever attracts those rules. This is not theorized. This is just what happens. So we don't have cases at the Constitutional Court in which the Vienna Convention on the Law of Treaties and its customary nature is discussed. By the way, Italy is party to the Vienna Convention. So if they will ever take into consideration those rules, they will probably invoke them as applicable to the Italian cases. So after this 5 minutes introduction, just to bring you in the specificity of the legal system, I'm sorry if after flying over the clouds yesterday, we are ground to positive law today. I speak to certain questions that I had in reading the cases and I try to answer. So let's go first to Article 10 and Paragraph 1 that talks of the Italian Constitution, that talks about the generally recognized principles of international law. In general, the Italian court took for granted certain very well-known international customs. In one case, there was an analysis of European law in general to apply a regional custom, so a European approach to criminal procedure in the treatment of, in the punishment of in juvenile cases. And by doing that, he referred also to the, to the Strasbourg cases and the European Convention, but to, in a certain way, to fertilize the raw analysis of practice. And here I can just confirm what Cedric said. In general, there's never an analysis about opinion, juris, and practice in the kind of course. It's always about consensus and state practice. So they don't borrow, also in this case from the international legal system, an approach that encompasses the two elements, but they just look for Moses and the others at what states do. So generally here includes also special customs because it is intended as usually. Article 10, Paragraph 1 of our Constitution actually says rules usually recognized by Italy and other states, enlarging the concept of customary rules in international law also to regional customs. So there are the two elements, absolutely not. In two old cases, famous case is Judgment 48 of 1979. It's famous because it's an early description of the counter limits. The Italian Constitutional Court analyzed a lot of international practice on consular relations. And it did it by applying and interpreting the Vienna Convention on consular relations. So again, I'm just happy you presented first because it used the subsequent practice approach that is well known for the Vienna Convention on the Law of Treaties and the idea of accretion. So we have something there, and look, the practice of states is actually that. So without applying the Vienna Convention, considering the practice, but here we have a sort of relationship between what has been written and what has been applied. It is an old case. It's 1979, judgment 48, but that's at least one case. Second case in which there is a very, very thorough analysis of state practice is in 1980 and regards the duty for residents in Italy that are foreigners of other countries to refrain from any kind of service for the country, not just military, but also the civil service. So there was a debate of whether they could, foreigners with residence in Italy had the duty to serve as civil service. So the Italian Constitutional Court did not give huge satisfaction to my research. So I moved down to the Supreme Court of Italy in the sense of civil and criminal jurisdiction, so the Cassazione, and the administrative court, the Consiglio di Stato. And I have to confirm that, in general, they've been obedient to the Constitution and they avoided dealing with written norms and with restatement of customary rules. But they had some very good researchers in ascertainment phase. In particular, there's one case, Venere di Cirene and Libya. It's under the administrative court. You have my name, and you can contact me with the email. If you're doing the research, I can send you all the precise decisions. By the way, there is a book in English that is the Italian Yearbook of International Law that has the last section all dedicated to Italian cases relevant for international lawyers, and it's translated into English. This is because in Naples there is a huge school that says that you have to start from domestic courts to understand international law. Professor Conforti and others. So Italian Yearbook of International Law, second part of the publication, always dedicated to this. It is in English. In Venere di Cirene in Italy, in Libya, the case was about the need to, or the claim to bring back to Libya a stolen statue. So the Consiglio di Stato really went through many legislations dealing with the duty of restitution of stolen pieces of art. So let's move to the last point of the presentation. The immunity saga opens the most interesting reflection on the problem of interpreting customary international law. And again, I have to share the conclusion of Cedric. Here, the Italian courts, more than focusing on interpreting a restatement of law, as for example the US courts do, they had the problem of putting together two customary, with a lot of brackets, norms, like jus cogens norms, and customary norms. Why I put a lot of brackets with jus cogens? Because of course, if jus cogens is customary, it's not jus cogens. I think that part of the idea of jus cogens is that it's not yet custom, or we really want to protect, even if it's not customary, something, and to put it above and against a rule that has been established through practice. So, among the many cases, so here the Italian Constitutional Court took one way in a couple of cases, and the Italian Cassazione took a very elaborate path that eventually was, stopped by the International Court of Justice in the immunity case, Germany against Italy. I'm not going into the many cases. I just like to point to one distinction, one idea that helped the Cassazione in putting together jus cogens norms and the provision to, let's say, not prosecute or not to take action against war crimes, and the idea, and immunities. In Boetia versus Germany, and in another case, in two cases, in 2011, the Italian Cassazione played on the concept of exception and established custom, precisely as had been told yesterday in the Abashe case. So the Cassazione in these two cases contested the existence of a custom regarding immunity from execution in case of war crimes. Precisely like the ICC yesterday. So it affirmed the existence of a custom in general. But the exception cannot be presumed because the rule, the general, lies in the possibility to judge, to adjudicate over a violation. And the exception for war crimes was never crystallized in any customary rule. So in this case, the systemic reasoning was not used about use cogens, while all the other cases, Ferrini, for example, and other well-known to the international law audience, because we published and commented, played on the relationship use cogens immunity. A couple of cases, especially Boetz and 9377 of 2011, dealt with the concept of exception, not demonstrated. And the court did not dig into a huge analysis of the practice. So, to go briefly to the end of my presentation, 17 minutes, okay? The Italian legal system has a strong prejudgment against the against the customary approach. This emerged also inside the court when cases about the Constitution itself and the way to read the Constitution was challenged. Because the Constitution is the highest source and powers struggle, there are now customary interpretation of the Constitution itself. When claims regarding some practice within the powers of the state have been brought to the court saying, no, the president cannot do that, or no, the parliament should do that, always the Constitutional Court was a bit dismissive. I'm not surprised to see a very dismissive attitude also in the Constitutional Court towards the customary process, reduced to an analysis of practice and not very thorough in the analysis of the content of the custom. However, the Court of Cassation and the Consiglio di Stato opens a couple of spotlights. And I think the most meaningful one, as for the interpretation of the content and the interpretation process of the custom, comes from the interplay between a rule and exception. That's the only relevant, meaty dynamic I've seen. While for the rest, there is a very basic approach looking at the consensus of states. And so it's all a problem of ascertainment of a specific rule in order to find the custom. Of course, the other point is about the use of the dialogue between use cogens and customary international law. But in this case, at the end, the whole enterprise started by the Cassation had some stop. So in a certain way, sort of failed experience. But that was also, to use your words, an attempt to establish a hierarchy between international law norms. Thank you.